Imagine turning on your television after school, watching a funny Pepsi commercial, and believing you had just discovered the greatest deal in history, not because you misunderstood it, but because the company itself seemed to make a promise so unbelievable that no one else took it seriously. No one, except one college student. That single decision would drag one of the biggest companies in the world into a courtroom, spark international headlines, and become one of the most famous marketing lawsuits in business history. This is how Pepsi's biggest marketing mistake became a $23 million lawsuit. The 1990s were known as the golden age of advertising. Television commercials weren't just trying to sell products. They were trying to entertain people. Companies spent millions creating bigger, funnier, and more outrageous commercials than their competitors. Among them was Pepsi. Locked in an endless battle with Coca-Cola, Pepsi wasn't just competing for market share, it was competing for attention. Every commercial had to be louder, smarter, more memorable. Because if people remembered your advertisement, they were more likely to remember your brand. It was during this fierce rivalry that Pepsi launched one of its most successful promotions. It was called Pepsi Stuff. The idea seemed brilliant. Every time customers bought Pepsi products, they earned Pepsi Points. Those points could be redeemed for branded merchandise, t-shirts, sunglasses, leather jackets, caps, duffel bags. The more Pepsi you bought, the more points you collected. The more points you collected, the bigger the rewards became. It was simple, it was fun, and most importantly, it encouraged millions of people to keep buying Pepsi. To promote the campaign, Pepsi released a television commercial unlike anything viewers had seen before. The advertisement followed a teenager getting ready for school. As each item appeared on screen, the number of Pepsi points required to earn it appeared beside it. A t-shirt, 75 Pepsi points. A leather jacket, 1,450 Pepsi points. A pair of sunglasses, 175 Pepsi points. The commercial was playful, fast-paced, exactly the kind of advertisement people expected from Pepsi during the 1990s. Then came the final scene. Instead of arriving at school on a bicycle or in a family car, the teenager landed dramatically in front of the school, flying a military Harrier Jump Jet. As stunned classmates looked on, the screen displayed one final message. Harrier Fighter Jet, 7 million Pepsi points. The commercial immediately ended. For almost everyone watching, it was obvious. It was a joke, a ridiculous punchline designed to make people laugh. After all, no company would seriously give away a military fighter jet, right? That's certainly what Pepsi believed. But hundreds of miles away, a 21-year-old business student named John Leonard watched the exact same commercial. And unlike everyone else, he didn't laugh. He paused. He replayed the commercial in his mind. Then he asked himself a question that Pepsi's marketing team had never considered. What if this wasn't just a joke? What if the advertisement had actually made a legally binding offer? Most people would have dismissed the thought within seconds. John Leonard didn't. Instead, he reached for a calculator, because if there was even the smallest chance Pepsi had accidentally made a promise, he intended to collect. What happened next would force one of the world's biggest corporations to defend itself against a claim so unbelievable that it would eventually be studied in law schools, business schools, and marketing departments around the world. Because John Leonard wasn't planning to buy millions of bottles of Pepsi. He believed he had found a completely different way to win, and Pepsi had absolutely no idea what was coming. Most people would have forgotten about the commercial before the next television program even started. John Leonard couldn't stop thinking about it. The more he replayed the advertisement in his mind, the more one detail bothered him. Pepsi had displayed an exact number, not millions of points, not a ridiculous amount. Exactly 7 million Pepsi points. To John, that mattered. In advertising, words and numbers have consequences. If Pepsi had intended the fighter jet to be nothing more than a joke, why give it a specific price? Curiosity quickly turned into research. John got hold of the official Pepsi Stuff catalog, expecting to find the Harrier jet listed somewhere inside. It wasn't there. Instead, the catalog explained how customers could redeem Pepsi Points for clothing, accessories, and other promotional items. At first glance, it seemed like Pepsi's case was straightforward. But then John noticed something else. Hidden in the promotion's rules was an option that would change everything. Participants didn't have to earn every Pepsi point by buying soft drinks. If they had collected at least a small number of points, they could purchase additional Pepsi Points for 10 cents each. To Pepsi, it was simply a convenience, a way for customers to top up their accounts if they were a few points short of a jacket or a pair of sunglasses. No one imagined someone would apply that rule to a military jet. John grabbed a calculator. 7 million Pepsi Points, at 10 cents each, worked out to $700,000. It was an enormous amount of money, but compared to the value of a military Harrier jet worth tens of millions of dollars, it seemed almost unbelievable. If Pepsi honored the advertisement, he wouldn't just receive an incredible prize. He would receive one of the most valuable promotional rewards ever offered. There was only one problem. John didn't have $700,000. Most people would have given up right there. John didn't. Instead, he shared the idea with a friend and experienced businessman named Todd Hoffman. At first, Todd thought it sounded completely absurd. A fighter jet? From a soda company? It sounded impossible. But as John carefully explained the promotion, the catalog, and Pepsi's own rules, Todd became intrigued. This wasn't about whether Pepsi intended to give away a jet. It was about whether the company had accidentally created an offer that could be legally enforced. The more they discussed it, the more serious the idea became. Eventually, Todd agreed to help finance the plan. Together, they assembled the required funds and prepared to put Pepsi's promotion to the ultimate test. Rather than buying millions of bottles of soda, John collected the minimum number of required Pepsi Points, attached them to the official redemption form, and included a cashier's check for $700,008.50, covering the cost of purchasing the remaining points. Everything was completed exactly as the promotion required. There were no tricks, no forged documents, no hidden agenda, just Pepsi's own rules, followed to the letter. When the package was finally mailed to Pepsi's headquarters, John wasn't expecting a joke. He genuinely believed the company would either honor its own promotion or explain why it couldn't. For Pepsi's employees, the envelope looked like any other customer submission. Until they opened it. Inside was a redemption form, a handful of Pepsi Points, and a cashier's check for more than $700,000. The room reportedly fell silent. Someone had actually done it. What began as a humorous television commercial had suddenly become a corporate problem, and Pepsi now faced a decision that would determine whether this bizarre story disappeared quietly or exploded into one of the most famous legal battles in advertising history. When Pepsi's marketing department received John Leonard's redemption package, their first reaction wasn't fear, it was amusement. To them, the answer seemed obvious. The Harrier jet at the end of the commercial was nothing more than a joke. Surely no reasonable person could believe Pepsi intended to give away a military aircraft. After reviewing the submission, Pepsi mailed John a brief response. The company returned his cashier's check and politely informed him that the commercial's final scene was simply humorous advertising. In other words, there would be no fighter jet. For Pepsi, the matter was over. But for John Leonard, it had only just begun. He wasn't trying to become famous. He wasn't trying to embarrass Pepsi. He genuinely believed the company had made a promise. And if a company expected customers to honor its promotions, shouldn't the company honor them too? Instead of walking away, John and Todd Hoffman hired a lawyer. His name was Michael Avenatti? No, not him. Years before that name became famous, John was represented by attorney David Rivkin, who carefully examined the promotion and Pepsi's response. The legal team believed the case came down to one simple question. Could a reasonable person believe Pepsi's advertisement was making a genuine offer? If the answer was yes, then Pepsi might have a serious problem. Pepsi's lawyers saw the situation very differently. To them, the commercial was obvious satire. No reasonable viewer could possibly believe a soft drink company intended to hand over a United States military aircraft in exchange for Pepsi Points. Both sides refused to back down. Negotiations quickly went nowhere. So John Leonard did something almost no one expected. He sued Pepsi. The lawsuit was officially filed in federal court in New York. Almost immediately, the case attracted attention, not because of the amount of money involved, but because of the prize. A Harrier Jump Jet wasn't a sports car. It wasn't a vacation. It wasn't a cash reward. It was one of the most advanced military aircraft in the world. Television stations picked up the story. Newspapers ran headlines across the country. People couldn't believe what they were reading. Some laughed at John. Others criticized Pepsi. Many simply wanted to know who was actually right. Suddenly, what had started as a clever marketing campaign became a public relations challenge. Pepsi now had two battles to fight. One inside the courtroom, the other in the court of public opinion. Every statement mattered. Every legal argument mattered. Because regardless of who eventually won, millions of people were now watching. Behind closed doors, Pepsi's legal team prepared its defense. They believed the law was firmly on their side. The advertisement, they argued, was clearly exaggerated for comedic effect. The teenager in the commercial didn't just arrive at school in a fighter jet. He landed it directly in front of the building while students casually watched. It was intentionally ridiculous. No reasonable person would believe it reflected a real promotional offer. John's lawyers disagreed. They pointed out something much simpler. Pepsi hadn't displayed the words, "Just kidding." Instead, it displayed a specific reward with a specific number of Pepsi points and a promotion with clearly defined rules. Now, the decision rested with one man, Federal Judge Kimba Wood. She would have to answer a question that no judge had ever faced before. When does advertising stop being entertainment and become a legally enforceable promise? Her decision wouldn't just determine whether John Leonard received a fighter jet. It would become one of the most important legal rulings in the history of modern advertising. The courtroom was quiet. There was no jury, no dramatic witnesses, no emotional outbursts. Just one question that would determine the outcome of the entire case. Did Pepsi actually make a legally binding offer? For John Leonard's legal team, the answer was simple. Yes. They argued that Pepsi had aired a national television commercial displaying a specific reward, a Harrier Jump Jet, for exactly 7 million Pepsi points. The commercial wasn't vague. It assigned a precise number. It promoted a real rewards program, and Pepsi's own rules allowed customers to purchase additional Pepsi points. John Leonard had simply followed those rules. If companies expected consumers to honor promotions, shouldn't companies be held to the same standard? From John's perspective, he wasn't asking for special treatment. He was asking Pepsi to honor its own advertisement. Pepsi's attorneys saw the situation completely differently. They argued that advertising must be viewed through the eyes of a reasonable person. And no reasonable person, they said, could believe a soft drink company intended to give away a United States Marine Corps Harrier Jump Jet. The commercial itself proved their point. The teenager didn't arrive quietly. He dramatically landed a military aircraft directly in front of a high school, while classmates casually admired him. The scene was intentionally absurd. It was comedy, not a genuine offer. Pepsi also pointed to another practical problem. A Harrier jet wasn't an ordinary prize. It was military equipment. Even if Pepsi had wanted to give one away, it couldn't simply purchase and transfer a combat aircraft to a civilian. The company insisted the advertisement was nothing more than humorous exaggeration. As both sides presented their arguments, the case became about something much larger than a fighter jet. It became about the limits of advertising. Could businesses be held responsible for every exaggerated claim made in a commercial? Or should consumers recognize obvious humor when they see it? After carefully reviewing the evidence, Federal Judge Kimba Wood delivered her decision. The court ruled in Pepsi's favor. In her written opinion, Judge Wood concluded that no objective, reasonable person could have believed the commercial was a serious offer for a military aircraft. The Harrier jet scene was clearly intended as a joke. Because there was no genuine offer, there could be no contract. And without a contract, there was no legal obligation for Pepsi to deliver the jet. After years of attention, headlines, and legal arguments, the case was over. John Leonard would not receive a Harrier. Pepsi had won, at least in court. But outside the courtroom, the story was far from finished, because something unexpected had happened. Although Pepsi won the legal battle, millions of people remembered the mistake. The lawsuit became one of the most famous examples of how a marketing campaign can create consequences no company ever intended. Law schools began teaching the case. Business schools analyzed it. Marketing experts debated it. Even decades later, companies continued studying the Pepsi Points lawsuit as a reminder that every advertisement carries legal and reputational risks. Ironically, the company that successfully defended itself in court had also created one of the most famous cautionary tales in advertising history. And perhaps the biggest lesson wasn't about who won. It was about what every business learned afterward. Because sometimes, winning the lawsuit doesn't mean winning the story. On paper, Pepsi won. The company walked away without handing over a Harrier Jump Jet. The court ruled that the commercial was an obvious joke. The lawsuit was dismissed. Case closed. But history rarely remembers only who won in court. Sometimes, it remembers who changed the conversation. And that's exactly what happened here. Long after the legal documents were filed away, the Pepsi Points case continued to influence businesses around the world. Marketing departments studied it. Corporate lawyers referenced it. Business schools turned it into a case study. Not because Pepsi lost, but because the lawsuit exposed something every company needed to understand. Advertising isn't just creativity, it's communication. Every word, every image, every number has the potential to shape what customers believe. If there's room for misunderstanding, there's room for risk. Today, companies spend enormous amounts of time reviewing advertisements before they ever reach the public. Lawyers often examine commercials alongside marketing teams. Promotional rules are written with extraordinary detail. Disclaimers appear more frequently. Terms and conditions have become longer than ever. The reason isn't difficult to understand. Businesses learned that one overlooked detail can become a very expensive problem. The Pepsi Points lawsuit became one of the clearest examples of that reality. But there was another lesson hiding beneath the legal arguments. It was about perception. Pepsi believed the Harrier jet was an obvious joke. John Leonard believed the company had made a legitimate offer. Neither side viewed the commercial in exactly the same way. And in business, perception often matters just as much as intention. A company can know what it meant to say. What truly matters is how customers understand it. That principle still shapes advertising today. The story also reminds us that curiosity can be incredibly powerful. While millions of people watched the commercial and laughed, One person asked a different question. What if they're serious? That single question led to one of the most unusual lawsuits in modern business history. Whether you agree with John's argument or not, his willingness to challenge a multinational corporation transformed an ordinary promotion into a global conversation. And perhaps that's why people still talk about this case nearly 3 decades later. Not because anyone expected a fighter jet to be delivered, but because the story sits at the intersection of marketing, law, psychology, and business strategy. It's entertaining, it's unbelievable, and yet, it actually happened. For Pepsi, the lawsuit became a reminder that even successful marketing campaigns can produce unintended consequences. For businesses, it reinforced the importance of clarity. For consumers, it showed that even the biggest corporations can be questioned. And for marketers everywhere, it became proof that the most memorable campaigns aren't always remembered for the reasons companies expect. The next time you see a commercial promising something extraordinary, take a closer look, read the details, ask questions, because behind every clever advertisement is a carefully crafted message. And sometimes, one small detail can change everything. Pepsi wanted to create one of the most entertaining commercials of the 1990s. Instead, it created one of the most famous marketing lawsuits in history, a lawsuit that still appears in classrooms, legal textbooks, and business discussions around the world, all because of one commercial, one college student, and one fighter jet that was never meant to leave the runway. Sometimes the biggest business mistakes don't happen inside a boardroom. They happen in front of millions of people, 30 seconds at a time. And that's how Pepsi's biggest marketing mistake became a $23 million lawsuit.